Hello, everybody.
Then I have number 5, 24200444708. John Garrett Smith appearing pro se. Do I have Mr. Smith?
Yes, present, Your Honor.
Okay, great. And then I have Attorney Bashford representing defendants. Is that correct?
Yes, good afternoon, Your Honor. With the court's permission, we have a Rule 9 intern here at the office, Lexi Hansen, who will be handling this matter if Your Honor will permit.
Okay, sounds great.
Thank you.
All right, Ms. Hansen, welcome. Going to do first this, so Mr. Smith, I'm just going to confirm, have you received the defense motion to dismiss in this case?
Yes, I have, Your Honor.
Okay. And I assume you'll be objecting today?
Yes, Your Honor.
Okay. So how I'm going to handle this proceeding, since it is the defense motion, I'm going to have them go first with any oral argument. Then I'm going to give you the opportunity to argue. So if you hear things while they're talking that you disagree with, rather than interrupting or telling me right then that you disagree with it, just wait for your turn. I will come to you. You'll get an equal amount of time to give me your side of the story. And then I will go back to Ms. Hansen and she'll have time for brief rebuttal. And then I'll make my decision.
Sure, understood. Thank you, Your Honor.
All right. So Ms. Hansen, go ahead.
Good afternoon, Your Honor. My name is Lexi Hansen, and I'm a Rule 9 intern working with the Attorney General's office, appearing on behalf of the defendants in this case and under the supervision of Michelle Hansen, my supervising attorney. The defendants moved to dismiss Mr. Smith's case on 2 grounds. First, because Mr. Smith has failed to properly file a tort claim with the Office of Risk Management, and in the alternative, because Mr. Smith has failed to exhaust his administrative remedies prior to bringing this cause of action. As to the first issue, RCW Chapter 4.92 governs tort claims that are brought against the state, its officers, and employees. And Section 100 of that same RCW requires that all individuals seeking to file claims of damages against the state, its officers, or employees to first file with the Office of Risk Management. Section 110 of this same RCW further requires that upon filing with the Office of Risk Management, that individuals wait 60 days until they file suit. The reasoning behind this is to allow government agencies such as the Office of Risk Management time to evaluate the claims being brought against them and to determine whether settlement is proper. The requirements of Section 110 are jurisdictional. This is noted in the case of Levy, which is a 1998 case from the Court of Appeals Division 2. And it notes that a failure to comply with Section 110 will result in dismissal for lack of subject matter jurisdiction. And here, Mr. Smith has not complied with the requirements of Section 110. Mr. Smith has not alleged in either of his complaints that he filed with the Office of Risk Management. And in fact, it would be a temporal impossibility for him to have complied with Section 110, given that he filed this cause of action only 5 days after the incidents alleged in his initial complaint took place. And on those grounds, the defendants would ask that this court dismiss Mr. Smith's case. In the alternative, reading Mr. Smith's claims charitably, our understanding is that Mr. Smith's reference to his civil rights implicates potential federal claims. And in the event that these are federal claims, Mr. Smith would be subject to the Prison Litigation Reform Act, which requires that incarcerants exhaust all grievance procedures and administrative remedies available to them prior to bringing suit. The Prison Litigation Reform Act was amended in 1996 with Congress intending to ensure that the judicial system wouldn't be overburdened by suits brought by prisoners and to allow correctional officials the time and opportunity to address complaints internally before allowing the initiation of a federal case. The place in which Mr. Smith has been in custody, Longview Reentry Center, like all DOC facilities in the state of Washington, conforms with the statewide resolution program, which we do note on pages 6 and 7 of our brief. Under that program, the time in which an individual files their initial complaint and for the appeals process we've gone through would take 90 days. And for the same reasons we discussed, it would not have been possible for Mr. Smith to have filed a grievance and gone through the grievance process in that time period. And for that reason as well, we would ask that the court dismiss.
Thank you. Okay, so Mr. Smith, it would be your turn to give me your position on the state's motion to dismiss, primarily based on what they are perceiving to be the two failures, kind of how you, in the method and manner that you started this lawsuit. So go ahead.
Sure, Your Honor. Thank you very much. And that was very well articulated. I'm familiar with the procedures of the Office of Risk Management. To me, this really boils down to an issue. And again, you can punt, it could be punted to the federal jurisdiction regarding 18 U.S.C. Section 3 and 4, laws regarding misprision of felony and harboring and aiding and abetting additional crimes. And this is really part of an 11-year story. It's the reason upon which we've been asking for disclosure of public records, over 400 that have been criminally ignored by state officials at all levels. And this is just a continuation of these issues. Regarding this particular incident, it's in essence what the defendant is trying to explain is that the rules and procedures for the Office of Risk Management essentially give a 60-day safe harbor for criminals employed by the state to do anything they want, regardless of the risk of the situation. The risk was on me. I had to report somewhere. I didn't have 60 days to wait. I'm trying to invoke upon common sense and the intent of law, which is to protect human rights. Regarding all these issues, and I want to state it for the record because this will be followed up by federal and international litigation. In no uncertain terms, it's clear public knowledge across the board that I've been wrongfully imprisoned for 11 years. Public records are not being disclosed. They've been requested. I believe incidents in this case and the records requested for it would expose those ongoing criminal acts that continue to this day. And I'm just appealing to the law for what it was based on and founded for, which was to protect human rights and basic dignity and not enable harassment, lies, deception, and fraudulent evidence, including this case. The whole issue upon which 2 more weeks were added to my sentence is completely fraudulent, laced with harassment and absolute hate crimes against autism, things that are far more paramount than procedures and protocols related to an Office of Risk Management. I want to state that for the record, and this recording will be invoked in ongoing litigation because the result of this statement made by the defense is the writing's on the wall. It's just another pathway for the state to claim that an innocent person wrongfully imprisoned is gumming up the court system when it couldn't be further from the truth. I've been seeking justice for over a decade in simple revelation of public records. Multiple state and federal laws mandate the disclosure, and there's no judicial officer in the entire state of Washington, Superior Court or federal, that will even pay attention to those laws. So what is a common man to do? This was one effort we took, And apparently it's been, loopholes have been found to just say it doesn't really matter. And our belief, my company's belief, my family's belief, my international partners' belief is that human life does matter and that basic common dignity it matters. And from an autistic standpoint, I can personally stand here and tell you that I continue to be appalled at the disgusting inferences that are made by state officials about my behavior. And it's appalling, it's atrocious, and it's wrong. That's all I have, Your Honor. Thank you.
Thank you. Ms. Hanson, any brief rebuttal?
Yes, Your Honor. To the extent that Mr. Smith has discussed any crimes, this is a civil case and this is a claim of torts against the state. I will also add that there is an abundance of case law providing that plaintiffs must comply with the statutorily created right to bring an action against the state, regardless of whether that requirement is harsh or technical. And if there are no further questions, Your Honor, we have prepared a proposed order asking that Your Honor dismiss Mr. Smith's case in full and respectfully ask that the court sign that order. Thank you.
Okay, give me just a minute here. Okay. So here's my ruling, and I am going to put some additional verbiage into the order. So Ms. Hanson, it's my hope that your office would just use the order that you've proposed, but add in a specific finding that I'm going to include. So, and then your office can submit that ex parte to the court for signature. So here's my ruling. I do find, I think it's very clear from the record that plaintiff has failed to file the statutory notice for instituting a tort claim. That is a jurisdictional requirement, very well settled case law that is a jurisdictional requirement. And the reason being is it does give then the state those 60 days to try to resolve these without being thrown into multi-million-dollar tort lawsuits. So I am granting the defendant's amended motion to dismiss without prejudice, and I would like that included in the order that I do sign. And Mr. Smith, what that means is I do find that at this stage, there is a statutory requirement that has not yet been met. But dismissing your complaint without prejudice means that you are free to refile within the statutory time frame after you comply with that requirement. So there's two types of dismissals. With prejudice means you can never bring the action again. Without prejudice means you can bring the action again. So my dismissal today is without prejudice. That is the type of dismissal that allows Mr. Smith to refile should he comply with statutory requirements that I believe are jurisdictional. Because I'm making my decision based on the failure to jurisdictionally file the tort claim with the state first, I'm not going to, I don't believe I have to reach the issue of the federal issues and whether there has been exhaustion of administrative remedies, but certainly I'm not ruling against the state on that. So they certainly can reserve that argument for future if this is to be refiled or if this is refiled. So that's my ruling. So Ms. Hanson, my hope is that we could get a new order from you all that just indicates it's an order granting defendants amended motion to dismiss without prejudice, and then specifically makes a finding that the court specifically finds that plaintiff failed to file the tort claim with the state as per jurisdictional requirement.
Will do. Thank you, Your Honor.
Okay. Mr. Smith, do you have any questions for the court?
No, thank you, Your Honor, for your jurisprudence. I appreciate it very much.
Absolutely. Thank you. You're all free to log out on this matter.
Be safe, be well, sleep sweet, and much love.